Well, there are strict rules. If there is any evidence of any foul play, if there is any evidence that judge has been impartial. So I think in that context, of course, if evidence is brought to light that for whatever reason, if a judge is even conflicted, that they're not able to be a judge in that particular case, it could well be because once when they were counsel, let's say they were a barrister, that they perhaps advised or represented one of the parties or a connected party to a party to the proceedings, maybe a group company. You see, so they have to declare their interest. So I think here in the justice system, the rules on impartiality are very strict. The rules on conflicts of interest are very strict. And we don't have what you perhaps see in some developing countries, being able to bribe judges, very strict on that. Certainly from my own experience, there may be decisions that I do not necessarily agree with, and in which case we have the right of appeal. You have another judge who can look at the case afresh. If you apply for permission to appeal, and if you're granted permission, then you go to appeal and the whole thing is looked at again. If you can convince the court that perhaps the judge in the lower court made some errors of law in the way that they made their decision. So from my personal experience, I don't see any compromise in the impartiality that judges show.